Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to learn from the Bombay High Court judgment that it is hard to believe that a widow having two children living in a densely or thickly populated locality was subjected to a rape several times. So before beginning the video, I want to caution you that every case depends on the facts and circumstances. It is only hard to believe. The word, please remember very carefully. In the case of Mr. Siddodhan versus State of Maharashtra in criminal application number 26241 by 2019, decided on 19/12/2022, the High Court bench, they opined that it is very hard to believe that a widow with two children, the two, a resident of thickly populated area, could not be forcibly raped several times. By now, you might have understood the essence of the case. So definitely, the woman was already married, having two children, so deserted or might have left husband and developed contact with our Siddodhan. Is it not? Right, basing our allegations that under the promise of marriage or something he has cheated her and enjoyed her or sexually exploited her against her consent. A case was registered against him under section 376 of the Indian Penal Code. FIR was registered against him. And this man approached the Honorable High Court of Bombay to quash the FIR under section 482 CRPC. You may know 482 means to do complete justice. So normally when we file the cases under 482, even if you don't get the so-called quashment orders, at least you will get the stay orders. That is the belief. Right. So the main allegation is the alleged repeated forceful rape and even taking away the ornaments from the prosecutrix. So he developed illegal contact with her. He has taken away her gold jewels. Then he parted her mortgage and sold them with a jeweler. And moreover, he has committed the so-called sexual act. This is the in brief facts of the FIR. But what about the evidence? See, the very important point. The jeweler clearly stated that the accuser, that is Siddodhan, and the prosecutor, both of them came to him. The prosecutrix herself handed over the ornaments to him. So they sold the ornaments. It's a fact that they sold the ornaments, but the prosecutor, she sold the ornaments. Both of them went to the jeweler. Then how can you say that he sold away her ornaments? He committed theft of her ornaments. So in this connection, please remember, normally if a wife puts up a case that the jewelry given by her parents was taken away by the husband, normally the police register case under breach of 406 of the Indian Penal Code. చాలా కేసులు జరుగుతూ ఉంటాయి. నా ఇంట్లో నగలు తీసుకొచ్చాం, కానీ మా అత్తగారు వాళ్ళు ఇంట్లో పెట్టుకున్నారు, తిరిగి ఇవ్వట్లేదు, లేదా వాటిని తీసేసుకున్నారంటే నార్మల్గా 406 అవుతుంది. సో హియర్ దే హ్యావ్ స్టేటెడ్ దట్ ఇట్ ఇస్ ద కేస్ ఆఫ్ 379. సో హీ సోల్డ్ అవే ద ప్రాపర్టీ. దానికి ఎవిడెన్స్ ఏంటి? బోత్ ఆఫ్ దెమ్, ఇద్దరు వెళ్ళారు, ఇచ్చారు. మరి థెఫ్ట్ ఎందుకు అవుతుంది? దట్ second point, there is a delay in the FIR. The FIR was lodged after 6 months. Of course, a delay can be explained properly because it's a relation, maybe living relation or sexual relation. So normally they don't come out immediately after this. Anyway, there is a delay of 6 months. So therefore, when the neighbors, when they were examined, the neighbors were unaware or they are totally unaware of the incident. So therefore, it is difficult to accept that a widow with 2 children residing in a thickly populated residential locality could be forcibly raped, not once but on several occasions. So this is the fact they have arrived at. And secondly, apart from the inordinate delay in lodging the FIR, the allegations of rape, so which are leveled against the so-called plaintiff or the accused, they do not inspire confidence in the court. That's why the prosecution has to prove the case beyond all reasonable doubt. So the evidence should inspire confidence among the judge. So the evidence did not inspire confidence. Therefore, ultimately, the affair is quashed and the application is allowed. So, see, at the outset, I told you, every case depends on the facts and circumstances. We don't know whether it's correct or not. There may be chances that the woman may be subjected to the so-called forceful thing, even in a densely populated house. What happened there? So even though it's a thickly populated area, when the person visited, she might have asked the children to go outside and play. Of course, her willingness will be, it may be under promise of so-called sexual act, promise of marriage, and something might have done. But anyway, in this particular case, so the allegation of rape is immediately thrown out because of her evidence. The evidence part is that jeweler did not corroborate her. Neighbors, they are totally unaware. Then how can you prove your case? So that's why Lady Justice will always close the eyes. They will hear what you say. Then they will give the judgment. That is what has happened here. Anyway, it's a good judgment which is useful for the so-called defense advocates. So please read judgment and enrich your legal knowledge. With this, I am concluding. Thank you very much.